Hello, I'm attorney Matthew Higbee, founder of RecordGone.com. A conviction in California can cause you to lose your firearm rights. This brief video will discuss the three most common situations that cause people to lose their Second Amendment rights. If you were convicted of certain misdemeanors that are described in California Penal Code Section 12021.1, you will not be able to own a firearm for 10 years from the time of your conviction. Now, these type of misdemeanors are typically violent misdemeanors like assault, battery, or things like stalking or terrorist threat, or other misdemeanors that involve the use of a firearm or deadly weapon. Now, again, this prohibition is from the state of California. It's a 10-year prohibition that starts from the time of your conviction. An expungement or record sealing will not restore your firearm rights. You will need to wait the 10 years even if you have your record expunged or sealed. The only way this can be lifted is if you get a court order from a judge, and the judge can only grant this court order if you are currently an employee of the state of California and your job requires you to own a firearm or possess a firearm. If your offense was a felony conviction, both state and federal law prevent you from owning a firearm for life. The good news is that in California, many offenses can be reduced to a misdemeanor. Those type of felony offenses are often referred to as wobblers. If your felony offense is a wobbler that is reduced to a misdemeanor, your firearm rights will be restored in California and federally. Now, to know if your offense was a wobbler, you need to know two things. First, if the offense allowed for, at the time of sentencing, allowed for the judge to give you jail time. If the offense says you can be sentenced up to county jail time up to 1 year or state penitentiary or state prison, the offense is a wobbler. If the penal code section which you're convicted of only allows for imprisonment, then the offense is not a wobbler. Now, the second thing will be, what sentence did the judge actually give you? If the judge gave you a suspended prison sentence or sent you to prison, the offense is not a wobbler. So the two things you want to look for are, one, make sure the offense the sentence for the offense could have included county jail time, and two, that you did not get sent to prison and that your sentence was not a suspended prison sentence. Lastly, a misdemeanor conviction for domestic violence can prevent you from owning a firearm. Federal law, often referred to as the Lautenberg Amendment, says that anyone convicted of a crime that meets the federal definition of misdemeanor domestic violence has a lifetime prohibition from owning a firearm. There's a couple things to keep in mind about this law. First, it only applies to misdemeanors. So if you had a felony domestic violence, this law does not apply, though other prohibitions may that result from it. The second is that expungement and record sealing will not restore your right to own a firearm that was lost as a result of a misdemeanor conviction unless the state also took away your firearm right as a result of the conviction and restored it as a right of the expungement. And finally, the last thing is, this law provides a narrow federal definition of misdemeanor domestic violence. Now, often cases, state laws define domestic violence more broadly. So there's a chance you may have been convicted of domestic violence or family violence or something that sounds like it might meet the federal definition just by its label, but an analysis of the facts of your case may show that it does not meet the federal definition. So there is a chance that if your firearm rights were denied because of misdemeanor domestic violence, that they may have been improperly denied. The end of this video will give you the definition of misdemeanor domestic violence. Take a look at it, read it carefully. It's very precise. And if you think, after reading it, there's a chance that your case might not meet the federal definition, and you'd like an attorney to analyze your case, or challenge a finding that you don't have challenge a finding that you shouldn't fall under the purview of that law, we'd be glad to handle that case for you.